Hi, Todd Orchide here with GTL Real Estate. Wanted to come to you today with a special video talking about the stimulus bill that passed the Senate last night. It was basically a unanimous vote, 96-0. A few senators were missing because they're in quarantine, but everybody who was there voted in favor. We expect unanimous consent on that from the House of Representatives here in the next day or two, and then all expectations are that the president will sign that within a day or so. Probably even the same day, just because of the importance of it. So this will be law very quickly. We don't anticipate any holdups on this. One congresswoman in particular has expressed that she might try to hold things up, but I suspect the Speaker of the House will make sure that that does not happen, and this will probably go through without a hitch by tomorrow. So before that happens, we wanted to make sure we got all the information out to you, because the way they're trying to do this, there won't be allotment for amendments or anything else on this bill. No special procedural votes. It's going to go through basically. That's the whole idea, is just push it through as it's written, get it done, and get it into law right away. So that's why we're going to go ahead and get this information out to you now instead of waiting until the bill is actually law. We want you to be able to prepare for this and have all the information available to you. And I apologize, I'm going to be looking down at my notes here during this video. I usually don't do that. I hate when people look down at their notes in a video. I always try to use a teleprompter or something for these things, but I'm not able to do that today just because of how quickly this has all happened. I just had to jot down some notes, and I wanted to get this stuff out to you quick, and there's just so much information. So please forgive me, I'm going to be looking down at notes a lot during this video. So first, the first thing I'll say is the bill is not very favorable towards landlords. So let's just get that out of the way, make that clear. In some other countries, like in Canada, they're trying to be, very accommodating towards landlords. There's proposals for things like the government directly paying rent to landlords on behalf of tenants. Well, the United States is not doing that. They're going about it a very different way, and the way they've done it is difficult for landlords and property managers. So, most of the information we'll give you today is not going to be good news, I'm sorry to say, unfortunately. So there is one good piece of news, though, and I'd like to start off with that. That is the piece of the legislation that deals with mortgage forbearance. So if you have a mortgage on your property that is federally backed, and what that means is an FHA loan or any sort of loan that is basically owned by Fannie Mae or Freddie Mac, any property that you through a government program such as Section 8, basically a wide range of loans. The only time this doesn't really apply is if you have a loan from a small local bank that does not sell their loans on the secondary market to Fannie Mae and Freddie Mac. And if you're not sure whether that's the case with your loan, call your mortgage servicer. That's whoever sends you your mortgage statement every month, and ask them. Find out if your loan was sold on the secondary market. But generally, if you've got a loan through any of the big companies, if you're serviced by Bank of America, Wells Fargo, Chase, any of the big companies, you can pretty much bet that that loan has been sold on the secondary market and you're covered. So assuming that your loan is, because it almost certainly is, then you have the ability to request from your mortgage company a 180-day mortgage forbearance. And basically what that means is you can go 180 days. If you have a hardship as a result of COVID-19, you have that 180 days where you don't have to make your mortgage payments. Now you can also extend that. You have to make sure you request that extension before your original extension runs out, but you can extend that by another 180 days. So basically you can get, for all intents and purposes, a whole year if you need it. Now, the law is very clear on this. All you have to do is request it and affirm that you have a financial difficulty as a result of COVID-19. There is no documentation required on this. The bank is specifically prohibited from demanding special documentation from you to prove your financial difficulty. They just basically have to approve it. If you say, I've got a difficulty, it's as a result of the COVID-19 problem, and that doesn't mean you have COVID-19. It doesn't mean that anyone in your family has it or that you've been quarantined. It just means that as a result of all of this situation, you have a financial problem. And that could be that your tenant just didn't pay the rent because the tenant says they've got a problem from COVID-19. Whatever the situation may be, you got a financial difficulty that's, as a result of all of this stuff going on right now. You have the right to request it. You don't have to provide any documentation. All you have to do is attest that this is what the problem is. I need the forbearance. Now, if you request that, they have to approve it. They cannot charge you any interest during the forbearance period, and they cannot charge you any late fees during that period. So now I will point out that doesn't mean that you're never going to have to make those payments. What it basically means is your mortgage is going to be extended out longer. So if you take 180 days, then your mortgage is you're going to have to keep paying for that 6 months at the end of your mortgage, and you're going to keep paying that original interest that you were supposed to pay. Now, additional interest isn't going to compound on there because they're not allowed to charge interest during this period, but you'll still have to pay all the original principal payments, all of the original interest that you would have paid. All of that will still be the same. You'll just basically be able to push it back that 6 months or a year if you make the second request for an additional extension. So, they can't charge you, they can't be compounding interest on you, they can't be charging you late fees during this period. Again, that's no documentation required. All you have to do is ask for it. In addition to that, there is a foreclosure moratorium during the next 60 days. Well, actually, the 60 days starts on March 18th. So it was a few days ago the period starts. So it's 53 days or so from today's video. That there are no foreclosures allowed to be initiated or carried out. So if you're scheduled to have a foreclosure occur a week from now, they've already gone through all the process and it's about to be foreclosed on. Assuming this legislation is ratified and signed by the president, that's going to stop. They won't be able to do that until after the 60 days, and they won't be able to start any new cases. Now, of course, this would really only apply for people who are already behind on their mortgage, of course, because if you apply for your forbearance, they can't be charging you mortgage payments, interest, or fees during that period, so there's no opportunity for foreclosure for them there anyway. So the foreclosure moratorium is basically dealing with people who are already behind because they can't foreclose on you during the forbearance period anyway if you start to get behind then. So, just in summary, you're eligible for up to 360 days of mortgage forbearance. You have to request it in 180-day periods. So request the first one, then before that period runs out, request the second one. No mortgage interest, no late fees, and they can't file a foreclosure on you if you get behind during that period. And they can't file a foreclosure on you during the next 60 days if you're already behind. That's the good news from the bill. So, excuse me, if your tenant gets behind and isn't paying you, you've got that relief. So, I know that a lot of you are saying that doesn't really help me. I've got repairs that I have to pay. I have taxes. I have insurance. It's not just my mortgage. I got all this other stuff I have to pay, and I hear you. I understand, and that's why we're telling tenants that they still have to pay the rent. We're doing what you pay us to do and doing our job. And by the way, we've gotten a lot of heat for that in the media. But we're doing what you pay us to do and trying to collect that. So I understand we're doing everything we can to keep collecting the rent from the tenant because I know it's not just your mortgage that's a problem. But at least you do have the relief on the mortgage in this bill. That's the good news. Now for all the bad news. So the bill includes an eviction moratorium. So what does that mean? It means that for any covered property, so a covered property again is any property that is through a government program such as Section 8, that is under a social program under the Violence Against Women Act, is federally backed by Fannie Mae or Freddie Mac, an FHA loan, any of those kind of things, then that's a covered property. So I would say probably 95% of the properties that we manage are covered properties, and that means it's likely that your property is a covered property unless you just own the property outright, with no mortgage, or if you have a loan through a small local bank, maybe a portfolio loan if you're an investor with multiple properties. that is excluded from the coverage or from the eviction moratorium. But those are basically the only cases. Pretty much any other loan that you have has almost certainly been sold in the secondary market to Fannie Mae or Freddie Mac, or it's an FHA loan. That's pretty common with our clients. A lot of our clients bought their houses originally as a first home and then later rented it out, so it's still under an FHA loan. So all of those are covered. So those are all the covered properties. It's almost certain it's yours, so I'll say that, but not necessarily. So if you have a question about whether your property is covered by this, you can check with your attorney or you can ask us. We can try to give you some advice. No, please know that we cannot give legal advice. So, we can try to give you a little bit of guidance to try to find your way, but you might need to consult an attorney on that. But if your property is covered, there is an eviction moratorium, and that eviction moratorium runs for 120 days. So basically 4 months. So we're looking April, May, June, July is the moratorium period. No eviction can be initiated or completed during that time frame. So basically everything comes to a halt. So what that means is we can't even tell our attorneys to file the eviction. Or if you're a landlord managing your own property, you can't file the eviction. Now, most likely your courts are just not going to accept the filings anyway, so the court clerk will make that really easy for you. They'll just probably tell you that you can't file it. But you are responsible for compliance with this, not the county clerk office. So they might accept it from you and you could get in trouble. So you need to know if you're covered by this, if your property is federally backed or your mortgage is federally backed, you cannot file an eviction during the next 120 days after this is signed, or you would be in violation of the law. Now, I will point out there's, as best I can tell so far, there are no actual penalties built into the law, but that doesn't mean a judge isn't going to come up with one. Don't file evictions if your property is covered during the 120 days. Now, please note this only deals with rent. The original proposal from the Democrats in the House was to prohibit basically all evictions, even if it was a violation of the lease, completely separate from rent. They were going to prohibit all of it. The compromise measure that was reached between the House Democrats and the Senate Republicans ended up changing that to make it only about rent, which obviously makes a lot more sense. If you have other kinds of violations, for example, somebody moves in a tenant that you didn't approve and your lease doesn't allow additional tenants, you can still evict for that, but you can't evict for non-payment. The other thing on this is we can't charge, and you can't charge if you're managing yourself, any late fees during this period of time. So during that 120 days, no late fees. I know this is a burden on a lot of you because, if you are, getting late fees yourself because you're getting a late fee on your credit card or whatever it may be because you're not getting that rent income to help you pay your bills, I know you count on, for us anyway, I know some property management companies keep the entire late fee. We split it with our owners. So you're used to getting that money if a tenant pays late, and now you're not going to get it, just like we're not going to get it. And I understand that's a burden. It's cutting our income, believe me. I understand your frustration there. I don't think it's fair, but it is what the law is. So we're going to have to stop all late fee charges during that 120-day moratorium. After the 120 days, then you're finally able to issue a late notice to the tenant and tell them that the rent is due and they got to pay or they have to leave. So we call this a notice to pay, rent, or quit in the states that we do business. Some states just call it a 3-day notice, a 10-day notice, whatever they have. But here's the thing. It's not just a 3-day or a 10-day or whatever your state has anymore. It is now, by federal law, a 30-day notice. So the 120 days ends, tenant hasn't been paying their rent, let's say. Now you can issue a notice. Instead of using your normal notice that says they have to pay in 3 days, that's what it is for us. Instead, it has to say a full 30 days. So now the tenant has that full additional month to catch up on whatever they're behind on. Only at the completion of that 30 days can you then actually file the eviction. So the important thing to remember there is if you've got tenants who are behind during this period, you want to make sure you get that notice sent to them ASAP after that 120-day period is up. If you wait a few days, that's more days you're losing because you're not able to get less than 30 days. The 30 days is hard limit written into law. It's the way it is, so you got to go by that. So effectively what we're dealing with here between the 120 days and the additional 30 days is we can't actually file any evictions for all intents and purposes until September. So, that's what you're looking at. I know that is a financial burden on a lot of you. I wish there was something I could do to find a way around it to help you out. There's not. I mean, it's very clear in the law. No loopholes to be found. It's just a strict across-the-board moratorium on evictions for non-payment of rent for that period of time. The other issue here, so it's not just a moratorium on evictions. It is also a moratorium during this same period of time, and we're talking about the 120 days here. You cannot issue a notice to vacate to your tenants during this period of time. No notice to vacate, and it doesn't say just for non-payment of rent. It is a complete across the board, no allowance for notices to vacate during this 120 days. Now that's going to raise a lot of legal questions because there are a lot of leases out there, especially for those of you who are self-managing. I frequently see leases that do not have a built-in extension period month to month, that they just have a hard termination date. Or they have a automatic 1-year extension. Now, that creates a big problem because obviously if you can't issue a notice to vacate and your lease says that if there's no notice given, the lease automatically extends for another year, you could be getting trapped into a full year of another lease without any ability to get out of that. So this is stuff that's probably going to have to be litigated to figure out what the courts are actually going to allow here. I don't know. So this is my guidance to you. If you have a lease that is set to expire in the next 120 days, or I would say the next 125 days, because you want to add on that extra few days for how long it's going to take them to ratify and sign this bill here in the next few days. So if you've got any lease that's supposed to expire before the end of, let me see here, April, May, June, July, before the end of July, then you need to get out a notice now if you think there's any chance that you're going to want this tenant to vacate at the end of this lease. Get a notice out to the tenant telling them you do not want to renew their lease, and then you can always withdraw that notice later if you want. You can always withdraw that notice to vacate, but you want to get that out before this bill is signed into law, because once it's signed, it's done. No more notices to vacate for 120 days. So if you need somebody to vacate in, say, June, let's say somebody's lease expires at the end of June, normally we would say that you have up to 60 days. That's what our leases say. Until the last 60 days of that lease, the landlord can give notice. Nuh-uh, not anymore. During this 120-day period, there are no notices. So you need to get that notice out before the 120 days starts. So let us know if you're one of our clients, if you need to get your tenant a notice to vacate during that 120 days, we need to do that now. So let me know right away if you don't intend to renew your tenant's lease over the next 4 months. Let me know so we can get that notice out to them now before it's too late. So that's a big thing that everyone needs to know. I think it's getting overlooked. It's not being mentioned in the news. So if you're just watching CNBC, CNN, whatever, they ain't talking about that, so you probably don't know about it. So that's something you want to make sure that you pay special attention to. Now, a final thing I'll go over on this is reporting to the credit bureaus. And I know a lot of individual landlords probably aren't doing this, but I know some who are, so I did want to mention this. If you report rent payments and non-payments to the credit bureaus, it's important to note that if you make a special payment plan with a tenant during this 120-day time frame, you cannot report the rent as late if the tenant is complying with the special payment plan you worked out with them. So let's say your tenant stops paying the rent during this next few months because they've got some sort of financial hardship from COVID-19. You're not allowed to evict them. You can't send them late notices. You can't charge them late fees. So, and the tenant says, you know what, at the end of this 4 months, I'm not going to be able to pay you everything that's come due, so I need to work out a payment plan. It's up to you whether you want to do that. There's no requirement for you to work out a payment plan. The way it's written right now in law is at the end of the 120 days, everything that was due during that period of time, they got to pay it right then, or you can issue the notice, the 30-day notice, and then evict. But if you want to work out a payment plan, then you have to treat that payment plan for all intents and purposes as the new lease, basically. If your payment plan is all of this rent due during the next 4 months, you can pay it in equal installments over the following 6 months. Let's say that's your payment plan you work out. Then you can't report anything to the credit bureaus as being paid late as long as the tenant adheres to that payment plan that you've worked out for them. So here's my advice on this. Number one, if you are going to work out special payment plans, you're not required to. Again, if you do, then you want to make sure you have a written policy for how you deal with this if you have more than one tenant, because you could end up getting yourself into a situation where you are inadvertently giving one tenant a better deal than you gave another tenant. And if the tenant that you didn't give as great a deal to happens to be a member of a protected class, that could come across as a fair housing violation. So you want to be very careful about this. If you're going to do payment plans, sit down at your kitchen room table, work out everything that you're going to allow, what your policy is, what you're going to offer to people. You know, you might have 3 or 4 different plans that people can sign up for, but work them all out, have them all written out in detail as to what those plans entail, and then offer all of those options to every person that you're going to offer a payment plan to. And don't offer payment plans to some tenants that request it and not to others. Now, that's not to say you have to send out a big blast email to all your tenants that says, hey, if you want a payment plan, here it is. I don't recommend you do that. But you can have a policy that says, anybody who contacts me wanting to set up a payment plan, these are the 4 different payment plan options I will give them. Have that all written out. It should be in a formal policy, and you should stick to it 100% so that every single tenant who requests it gets the same offers and has the same opportunities. And again, if you do that, if any of those tenants sign up for those payment plans, you have to treat that plan as if that is the requirements of their lease. So you cannot report that they're late if they go by that. You have to still report to the credit bureaus that they're paying on time. This could be an issue for you if you're using property management software and that it's automatically reporting to the credit bureaus. You might need to turn off that automatic reporting. You might need to turn off the charges on the tenant's ledger so it doesn't look like they're late. You know, it just depends on your property management software, how you have everything set up. Figure that out, because if you've got automatic credit reporting, don't rely upon the agency that you use to report that to fix this problem for you. You need to make sure that it's working right so you're not in violation of the law, because there are serious penalties. All this other stuff we've talked about, there are no penalties that we've been able to find yet anyway, written into the stimulus bill. So if you were to violate, for example, the notice to vacate provision, it is breaking the law, but there's no specific penalty written into the law as to what would happen to you. It doesn't say if you violate this, then you'll owe $5,000 penalty. It doesn't say that anywhere. Now again, a judge could theoretically come up with something, but it's not written into law. On the other hand, the Fair Credit Reporting Act, the FCRA, has very specific penalties built in, and they are very serious. Thousands upon thousands of dollars you can get hit. And that's basically what they have tacked this onto in this bill. They basically added this provision to the FCRA, so those penalties in there would apply to you if you violated this part. So it's very important, don't report negative information to the credit bureaus if a tenant has worked out a payment plan with you and they're adhering to that payment plan. Now, if your property is with us, you don't have to worry about this. We'll take care of all that for you. It's not an issue you got to deal with. One of the many reasons, by the way, that all of you that are managing your property yourself should probably hire a manager so that they can take care of all these issues for you. But you know, if you're not doing that, if you're managing it yourself, just be careful about all this stuff, because it's hard telling. Even the things that don't have penalties built into law, you never know what some county magistrate is going to come up with in a ruling. You just never know. So it's always best to just make sure you stick to the law 100%. You know, even if there's no penalty built into it, just go by what the law says. Final thing I want to point out here. There may be an eviction moratorium. There may be a foreclosure moratorium. There may be a mortgage forbearance period. But what there is not, despite all of this, is a moratorium on you paying your property taxes, a moratorium on you paying your insurance, a moratorium on you paying your management fees, on paying your repair bills, any expense you have on your property. And all of us as landlords, we all know we've got a lot of expenses that could go beyond our mortgage payment. So there's nothing in the law that puts a forbearance on any of that stuff. So your insurance company, they're still going to expect to be paid. We've heard nothing from any insurers that they're planning on waiving anything. Certainly nothing from the government that they're going to waive property taxes. They still expect their money, of course. So what I'm trying to say is, even though they're telling tenants basically that you're not going to have an eviction filed against you, and even though they're telling you don't have to pay your mortgage, we know you've still got a lot of expenses beyond that as a landlord. You've still got to pay all those, unfortunately. And the big one there is repairs. So I wanted to cover this because the warranty of repair, as it's frequently called, says that you as a landlord are required to repair anything that breaks at the property that the tenant didn't break, basically. So if your refrigerator, if you lease your property with a refrigerator and it stops working, you are required by law to fix it. You can't just tell the tenant, well, it doesn't have a refrigerator anymore. The law doesn't allow that. You're required to fix it. This stimulus bill, even though it's allowing all these other forbearances and everything, all the moratoriums, it does not change that. You still have that requirement under law. Now, I will say there is one state in the union that I'm aware of, Arkansas, that does not have a warranty of repair, so it's different for you guys. But for everybody else, as far as I am aware, 49 other states in the union have some sort of warranty of repair that requires you to fix things if they break. You can't change that now. If your tenant stops paying the rent for these 120 days, you can't tell them, you know what, I'm not going to do that repair because you aren't paying your rent. I'll hold off. I'll do that repair when the 120 days is over and if you pay me. If you say that, you're breaking the law. There may be penalties in your state law for how to deal with that. Could even be what they call treble damages, which means 3 times whatever the value of that is. So there could be serious penalties is what I'm trying to say. So you still have to keep doing your repairs. Don't think that you can get out of doing those just because the rent income isn't coming in. I know that's a burden on you. I know it's unfair. The government isn't always fair, unfortunately, is all I can say there. And they certainly were not fair to landlords in how they've structured this law. So, just keep that in mind. This is why we always recommend to everybody to have the 3-month reserve. Now, I know the 3 months that we've always recommended doesn't really help when there's a 120-day eviction moratorium. That's longer than the reserves we tell you to keep around. Never in a million years did we expect that the government was going to ever allow tenants to go 4 months without an eviction being filed. So in future videos, I might need to tell people to have a 6-month reserve fund set aside as a landlord. But you never know if even the government might do something different than that later. So all I can say is hopefully you have a reserve set aside. Hopefully the mortgage forbearance provision will help you out enough that the 3 months that you have set aside for reserves is enough to cover repairs and other expenses that come up. If it's not, obviously that's a very difficult situation. Hopefully the government is going to come up with, in phase 4, 5, 6, however many there are in the stimulus package that they're working out. We're on phase 3 now. So hopefully they are going to come up with additional help for you. We haven't heard about any of that yet. We don't know if that's going to occur, but hopefully that is the case as lawmakers start to hear from our lobbyists and from many landlords out there, from the National Association of Realtors, hopefully. Hopefully they start to get a sense that this is becoming a real problem for people and that they need to provide additional assistance for landlords. Right now that's not there though, so I just need to put that out there and let you know. You still got to get your repairs done, pay your insurance, taxes, all the other expenses you have. Unfortunately, they aren't giving you any help with that. For some reason, they think landlords should just eat it. And, as unfair as that is, that just seems to be the reality right now. So just wanted to make sure you're aware of that. Now, I know this is a whole lot of information. So, if you have questions about this, please send me an email and let me know. We will obviously be very busy dealing with all of these changes. We have software changes we have to make. We have to change all of our notices. Plus, we're still dealing with all the problems from, we have tenants who are infected with COVID-19 right now. We're dealing with trying to get vendors to do repairs and inspections through all this while they're making additional precautions. There's just so many things going on. I can tell you I'm about a week behind on my emails right now. I'm trying to get to them. I know everybody on our staff is very busy. Everybody across the industry is busy. So I apologize for how long it is taking us to get back to you on some of those questions. We're doing as quick as we can, and hopefully things will start to slow down and we can start to get those responses to you more quickly. But if you have questions, please let us know. Final thing I want to go over before the end of this video is for our clients, or for anyone out there who is thinking about possibly being one of our clients, there is a program that might be of help to you that we have available called SureVestor. SureVestor is a landlord insurance program. I've done videos on this before. You can look at those if you want more detailed information. But the idea of this insurance plan is that it covers you if your tenant has to be evicted or skips out without paying the rent. It also covers attorney's fees, lock change fees, malicious damage. It covers a whole lot. It might be something that would help you out in this situation. Now, the problem, I will say, I'll point this out, so just so you're aware, the program, the insurance does not pay out until the end of the situation. So that would be, in this case, 5 months from now when the tenant can be evicted, you would get paid back for the lost rent. So you'd have to wait until the end when the tenant is actually evicted. That's when you'd actually get the money paid out on the claim. But you would get the money back. So if you could put expenses on a credit card or take out a savings during that period, you would end up getting that money back from the claim. Now, the policy that we use is what's called their Ultimate Package, which provides up to 3 months or 12 weeks, they do it in weeks, 12 weeks of protection for an eviction and $4,000 worth of legal fees. So, it covers a whole lot. Obviously, that doesn't cover the full 120 days plus the 30-day period. I understand there's still some there uncovered. I'm sure SureVestor, when they were putting together their packages, never thought in a million years either that an eviction would take this long. But that, at least it is 3 months of coverage, which is significant. So if you're one of our clients and you want to sign up for this, please reply to this email that I'm sending this video out in. Let me know. We'll get you signed up for that. Of course, there is an additional cost. Got to point that out. We can go over that when you email me. Got to pay for the insurance product, of course. But if you're not one of our clients, if you're watching this video, you're an independent landlord out there, this insurance through SureVestor is not available in the open market. SureVestor only sells policies through property managers and only through a select number of property managers also. There's only a few who are doing that in our markets. So if you're a landlord out there, you're worried about what's going on, and you want to get signed up for this insurance coverage, you'd have to sign up with us to manage your property, and we could get you signed up for the SureVestor also. If you want this program and you're one of our clients, you got to let us know right away, because when April 1st rolls around, if the tenant doesn't pay the rent, it's too late to sign up at that point. The policy cannot be purchased after the fact. It's just like car insurance. You can't buy car insurance after you've gotten into the car accident. You have to have it before. So, we have to get that policy purchased before the end of the month. So let us know if you want that, and we'll get that done. Those are the emails we are prioritizing right now today, is getting all those processed and purchasing those policies. So make sure you let me know if that's the case. So that's it for now. I know this is a very long video. We're over a half hour now. There's a ton of information covered. I apologize for that. There was just so much we had to get to. But if you have any questions, please let us know, and we will continue to update you on all this. I want to point out this was, of course, all preliminary information. It's always possible that additional bills will be passed, or that new interpretations will be made by HUD or some other agency. They could change some of the guidance that was in this video. So make sure you follow us on our YouTube channel in case we post updates to this that modify anything that was in this video. We are also not attorneys. I need to point that out. We frequently seek advice from our attorneys, but we are not attorneys. We cannot give legal advice. You should always seek competent legal counsel before taking anything you've heard in this video as gospel. It is not. You should speak to an attorney, a competent attorney who deals only in landlord-tenant law or primarily in landlord-tenant law, and get advice from them. So wanted to point out all those disclaimers. I know everybody hates legal disclaimers. We got to do them. But hopefully this information has been helpful to you. If you have any questions, let us know, and we'll be talking to you again soon.